Good day. We are Group 5 of 3M3 from Marketing Management, and we are here to present to you the case of EGV Realty Development Corporation versus Court of Appeals, General Register number 120236, dated in July 20, 1999. For the parties of the case, the petitioners are EGV Realty Development Corporation, or EGV Realty, which is the owner of a 7-story condominium building known as Christina Condominium. Christina Condominium Corporation, or CCC, holds title to all common areas of Christina Condominium and is in charge of managing, maintaining, and administering the condominium's common areas and providing for the building's security. The respondent is Unisphere International Incorporated, or Unisphere, which is the occupant of Unit 301 of said condominium.
For the facts of the case, on November 28, 1981, the respondent's unit was allegedly robbed of various items valued at 6,165 pesos, and the issue was then reported to petitioner CCC. Another robbery allegedly occurred again on July 25, 1982, where the items stolen were valued at 6,130 pesos, bringing up the total value of items lost at 12,295 pesos. This issue was then again reported to petitioner CCC. On October 5, 1982, the respondent demanded compensation and reimbursement for the losses incurred due to the robbery. Petitioner CCC denied liability for the losses and stated that the goods lost belonged to Amtrade, a third party. Respondent Unisphere withheld payment of its monthly dues starting November of 1982 due to the denial of CCC.
On September 13, 1983, respondent Unisphere received a letter from CCC demanding payment of past dues. On December 5, 1984, petitioner EGV Realty executed a deed of absolute sale over Unit 301 or 301 in favor of respondent Unisphere. Afterwards, condominium certificate of title number 7010 was issued in respondent Unisphere's name, bearing the annotation of a lien in favor of petitioner EGV Realty for the unpaid condominium dues in the amount of 13,142.67 in peso. So, on January 28, 1987, petitioners EGV Realty and CCC jointly filed a petition with the Securities of and Exchange Commission (SEC) for the collection of the unpaid monthly dues in the amount of 13,142.67 against respondent Unisphere. So, on January 11, 1989, SEC hearing officer Antero FL Villaflor Jr. rendered a decision which ordered the respondent to pay petitioner the sum of 13,142.67 within 15 days from receipt of this decision. Further, petitioner is hereby ordered to pay respondent within 15 days from receipt of decision the sum of 12,295 pesos. On July 17, 1989, both parties filed for their respective motions for reconsideration, and the decision of hearing officer Villaflor was modified and amended by hearing officer Enrique L. Flores Jr., and wherein the respondent's motion was denied and the petitioner's motion was granted. The decision dated January 11, 1989 is partially reconsidered because the petitioners are not made liable for the value of the items or articles burglarized from respondent's condominium unit. So for this issue, or for the issue, whether or not set off or compensation took place in this case, according to Article 1278, 1279 of the Civil Code, compensation or offset takes place when two persons in their own right are creditor and debtor of each other. That in order for the compensation to be proper, it is necessary that each one of the obligors be bound principally, and he be at the same time a principal creditor of the other. In this case, the compensation or set-off is not applicable since there is a lack of evidence to show that the petitioner EGV Realty, the owner of the CCC, which is Christina Condominium Corporation, and respondent Unisphere are mutually debtors and creditors of each other.
For the decision, a distinction must be made between a debt and a claim. That debt is a claim which has been formally passed upon by the courts or quasi-judicial bodies to which it can in law be submitted and has been declared to be a debt. On the other hand, a claim is a debt in embryo where it is mere evidence of a debt and must pass through the process prescribed by law before it develops into what is properly called a debt. In this case, what the respondent Unisphere has against the petitioners is just a claim, not a debt, or is a debt in embryo. There is no doubt that the respondent Unisphere is indebted to the CCC for its unpaid monthly dues amounting to 13,142.67 cents, which was admitted. But whether the petitioner CCC is indebted, the respondent was vigorously disputed by the former. To add, it must be noted, on September 23, 1983, Unisphere abruptly stopped paying its monthly dues to the corporation without informing the latter. It was not until February 24, 1984, or 5 months later, it informed the corporation that it had suspended the payment of the condominium dues to compensate for the losses from the robberies. The petitioners EGV Realty and Christina Condominium Corporation would have this court consider in their favor Mr. Alfonso Zamora of Unisphere's admission that there was no such agreement among the unit owners that any member who suffered losses would be indemnified from the common contribution. The appellees further argue that the security agency, rather the corporation, should be sued for reimbursement of the value of the items stolen during the robberies. With the lack of evidence against the EGV Realty, the petition was granted, meaning they won the case. The decision of the Court of Appeals dated February 17, 1995 is reversed and set aside. The order of the Securities and Exchange Commission dated August 21, 1990, reiterating the hearing officer's decision dated January 11, 1989, is amended by the order of July 17, 1989, was reinstated.